An NFT, or non-fungible token, is a unique identification code and metadata recorded on the blockchain and linked to an underlying asset. It could be more simply seen as a digital limited edition of the underlying asset, which is usually an artwork such as songs, music albums, computer games, pictures or videos, but it could also be used for other purposes such as real estate.
If you have just bought an NFT of the latest music album of your favorite band or artist, you are in fact the proud owner of the software code in a form of a token which contains, first, a unique identifiable number and the historical information of any transaction in relation to the token. As the blockchain is deemed to be forgery-proof, it means that you are, and will remain, the sole owner of one digital copy of the album until you decide to sell it to somebody else. Second, the NFT will also include such digital copy of the music album and further details of the right that you have in relation to the digital copy of the album, and as the case may be, the original artwork.
A lot of noise has been made around famous NFTs which were sold for hundreds of millions of dollars and which underlying artwork, such as pictures, customized monkey faces or tweets, was often mocked for its so-called poor quality. Without a quality judgment on the underlying artwork, the value of many of the top-selling NFTs seems to be mostly relying upon speculation and is often disconnected from the rights associated thereto. In that respect, it is therefore crucial for both NFTs buyers and sellers to know what they are buying, selling, and what they are not. What are the legal rights in relation to the NFTs?
A common misconception about NFTs is that they would give some sort of ownership or rights on the underlying asset. There is in fact here no difference between buying an NFT of a music album and a good or physical copy of the same music album. In both cases, a limited edition copy of the album is owned, either digital or physical, but such ownership does not involve any transfer of rights unless it is explicit.
An NFT seller can of course assign or license the intellectual property rights in the underlying asset alongside the NFT, even though it is rarely the case. But such transfer or license should be explicitly written in either the description of the rights accompanying the NFT or otherwise. In the absence of an express assignment or license of the IP rights in the underlying asset, the NFT would solely remain a digital copy of an artwork through software code recorded on the blockchain, but nothing more than that. For example, owning an NFT of a personalized cat picture without having been assigned or licensed any rights in relation thereto would only allow to display it for personal use and to resell it. It would not be possible to prevent others from digitally using the same picture, as only the owner of the IP rights associated to the original picture would be allowed to do so.
NFTs also involve the risk of infringing IP rights of third parties. This would namely be the case if an NFT involved the creation of the digital copy of an underlying physical asset. For example, the creation of NFTs of Nike shoes or Hermes bags without having been assigned or licensed the related copyright, design right or trademark rights by Nike or Hermes may well constitute infringement of such rights.
If NFTs will represent huge opportunities for artists and business in the future, they will also be accompanied by non-negligible risks and legal uncertainties. So far, very few case law has been published in Europe around NFTs, and it is therefore difficult to fully anticipate the legal issues arising from their creation, use, and economic exploitation.
The main advice for all that are interested in either creating or buying NFTs is to focus on the legal rights accompanying the NFTs and to closely follow any legal development on the topic. NFTs will not be subject to MiCA, the EU proposal for regulation and market in crypto assets.